Of course, you know that Tamir himself was killed on November 22nd, 2014. That's when the shooting occurred. By March of 2015, Prosecutor Tim McGinty, the elected Cuyahoga County prosecutor, met with the family's counsel, assured them of a fair investigation and a fair grand jury presentation. Grand juries are a group that meets in secret of ordinary citizens, but they hear a one-sided presentation from the prosecutor. So when the prosecutor wants to have somebody charged, the prosecutor asks for that and presents the information in such a way that they're seeking it. But here what we saw was a kind of feigned agnosticism by the prosecutor that, gee, we don't know what's going on. We don't know what we want. The family's counsel met with assistant prosecutors Gutierrez and Meyer. They refused to state what their viewpoints were, which was the first red flag, because they kept making comments about how they're going to hire experts, and they kept claiming it's up to the grand jury, when we all know, you've probably heard the adage that a grand jury would indict a ham sandwich if the prosecutors asked for it. Here they were suddenly pretending that, gee, they don't have a viewpoint. They have no idea what they want. That was in September of 2015. By October of 2015, the prosecutors claimed to us as the Rice Family Counsel that they don't know when they're going to release those expert reports that they're getting. That, it turns out, was a lie. That very afternoon, we learned from media, they had received the materials. So they just lied to us. The prosecutors launched a sneak attack through the media where they released deeply flawed so-called expert reports. Those reports assumed facts for which there was no evidence. For example, they assumed the officers will say this, the officers will say that, when in fact the officers had not yet testified to anything. We then sent a letter to the prosecutor about the undue delay in the investigation and critiquing the flaws in those so-called expert reports. We got no response whatsoever. You may recall that also in mid-November, Prosecutor McGinty publicly attacked Samaria Rice and her counsel. We then wrote a letter saying, you need to recuse from this investigation, or at a minimum, you need to announce to the public what your planned recommendation to the grand jury is. It is, after all, normal. Any former prosecutor will tell you it's normal for a prosecutor to make a request of the grand jury, charge or don't charge. McGinty promised, having abused this whole system with his so-called experts, he then promised he would put the Rice family's experts into the grand jury and let them present their findings. These were former law enforcement officers, two of them, who both said that the use of force was completely unjustified here and that the officers' tactics and behavior was completely off the map for what officers should normally do. They wrote written reports. We gave those written reports to the prosecutor with the expectation that those would be given to the grand jury in advance of their testimony. Instead, these two stoic former law enforcement officers came out, and you know what they told us? They said it was clear that the grand jurors did not have those reports in front of them. And second, they were not permitted to present their findings in a summary form to the grand jury. Instead, they came in, and it was an immediate attack by the prosecutor with question after question, with no overview presentation permitted by the experts. And one of the assistant prosecutors, according to one of our experts, pointed the airsoft pistol at the expert and said, what do you think about this? Which, as we all know from the videotape, is not something that occurred during the incident at all. Now, what's the smoking gun here when I talk about subversion and perversion of the process? It's this. We know, because the union bragged about it. Ordinarily, we wouldn't know what happened before the grand jury, right? Because it's a secret proceeding. We know about this because the union bragged about it. These officers were permitted to go before the grand jury, take the oath, and read pre-written statements, and then leave without taking any questions or cross-examination, as if they were politicians at a press conference. Now, you have to keep in mind, any criminal defense lawyer will tell you that they would never permit their client ever to testify before the grand jury, because it's a one-sided presentation in which the target of an investigation is going to get massacred by the prosecutor without any opportunity for their own lawyer to try to correct anything. So it's not normal for the target of a criminal investigation to even testify before the grand jury. So the only circumstances in which they would have gone in and testified would have been if they were promised special treatment beforehand. That's the only way any criminal defense lawyer worth their salt, and these officers had a pretty good criminal defense lawyer with a good reputation in town, they were permitted to go and read these pre-written statements and walk out without facing questions. What would have happened differently if the prosecutors had properly cross-examined these officers? Well, they would have shown, for example, that Officer Garmbach said that the window was rolled up because after all, it was a wintry day. But then Officer Lohman claimed that he was repeatedly shouting out commands to Tamir, which we know didn't happen when he got out of the vehicle because he got out fired immediately. And what would have happened? We would have said to Lohman, what are you in the habit of shouting out commands in a fastly approaching vehicle with the window rolled up? It just wasn't credible testimony. And a prosecutor who was cross-examining would have pulled this out. And that whole business of leaving without taking questions, contrary to a US Supreme Court opinion from 1958 that says, once you've taken the solemn oath and you've testified, you can't put that Fifth Amendment privilege genie back in the bottle. You are now subject to cross-examination on the same subject matter. So when McGinty said, oh, they invoked Fifth Amendment privilege, it was completely preposterous. And if they'd really done that, absent a special deal, he could have gone to the court and said, no, they have to be ordered to testify. They don't have a Fifth Amendment right once they've gone in there. What did the prosecutor do? He did the same thing that you'll see the Trump administration did last year. They waited until between Christmas and New Year when it was cold and wintry and people couldn't protest and organize themselves. And that's when he released the grand jury result. He went on a PR offensive. That was December 27th, 2015, between Christmas and New Year. The prosecutors' representations to the media contradicted their representations to us. The prosecutors, for example, told us as lawyers, hey, when we did enhanced stills from the video, we presented these things to the grand jury. When we presented the enhanced stills, hey, there was no big deal. There was nothing different about them. But they claimed to the media that those enhanced stills were a game changer. They kept contradicting themselves. Now, a big thing that was going on throughout this case was people kept saying, well, gee, we should let the Attorney General investigate it. But Attorney General DeWine, now our governor, tried to normalize Prosecutor McGinty's failure to cross-examine the officers. He said he too wouldn't do it in, quote, cases like this, that he would never make a recommendation to a grand jury in a use of deadly force case, which again is another form of special treatment because prosecutors always make the call on what they want the grand jury to do. Cleveland Scene magazine reported in January of 2016 that apparently there was no grand jury vote at all for a no bill of indictment. And then the prosecutor produced a strange document that isn't a real no bill. So we don't know to this day whether that grand jury actually voted. When all of this happened, we then turned to the Department of Justice and we said, this was a process that was unfair. We now need the federal government to investigate this killing by these officers. They started looking into the investigation. They started investigating. But unfortunately, that investigation was not complete by the time of the Trump transition. We then saw the federal government go silent. There was minimal contact back and forth. We didn't hear anything for a long time. And then finally, last October, we learned from the New York Times and the Washington Post that apparently 2 career civil rights prosecutors in the US Department of Justice, non-political folks, had said that they wanted to convene a federal grand jury to investigate these officers. And they sent 2 memoranda upstairs asking for permission to do so. Usually, and I say this from my experience as a federal prosecutor myself, it takes a matter of days or at most a couple weeks for your supervisors to approve that. Here, they sat on it for months and months such that a second memorandum was sent. Still no answer. And apparently, a whistleblower, we think it might have been one of these career prosecutors, made a report to the Inspector General of the Justice Department saying they're politically interfering with us. They politically interfered with this investigation. A federal statute requires the Rice family to be informed about progress in the investigation and certainly to be told whether it was closed. The Trump Justice Department under Attorney General Barr failed to do that. Instead, the Washington Post and New York Times reported they quietly closed the investigation, hoping, I guess, nobody would notice, and they didn't tell anyone. These career prosecutors left, and what we have now, according to the New York Times and the Washington Post, is a situation where there's the specter of political interference with that investigation because the career folks wanted to pursue this.